The Vice President.
Minister of National Security.
Thank you very much, Mr. Vice President. Mr. Vice President, just before the break, in my contribution, I was sharing with my colleagues in the Senate, as well as the public, what I believe are the startling statistics, which are an accurate reflection of reality that we face in Trinidad and Tobago at this time. So just to put it back into context, for the period the 1st of January to the 11th of November, which was yesterday, 2019, 625 woundings and shootings with firearms were recorded in Trinidad and Tobago. So up to yesterday, for this year, 625 shootings and woundings via the use of illegal firearms are recorded as our reality in Trinidad and Tobago. Even more startling than that, Mr. Vice President, is that of the 455 murders committed for the year as at yesterday's date, 455 too many. 365 were committed using firearms. So let the people of Trinidad and Tobago understand, as they do on the ground, as they do on the street, as they do in the various communities affected with the scourge of illegal firearms, that of the 455 murders committed for the year as at yesterday, 365 were through the use of illegal firearms. So only 90 murders in Trinidad and Tobago for the year to date as of yesterday were not committed through the use of illegal firearms. And I repeat it because it is worth repeating over and over, Mr. Vice President. The only reason a person would have an illegal firearm in his or her possession is to fatally harm another individual. There is no legitimate reason to have an illegal firearm in Trinidad and Tobago. Absolutely none. These are not toys. These are weapons made to kill people. And just to bring that squarely into context at this stage, Mr. Vice President, to the public out there, for them to understand, because I'm certain by this time and at this stage, the members of the Senate, the right-thinking members of the Senate, the civic-minded members of the Senate understand what is the reality that we are facing as citizens of Trinidad and Tobago out there. This bill here today, 3 clauses, as the Attorney General said, is simply to address what we have defined as prohibited weapons, artillery or automatic firearm, a grenade, bomb, or other like missile. And you see, Mr. Vice President, again, I challenge any member of the Senate to go outside of the precincts of these hallowed halls and to ask any person in Trinidad and Tobago who's law-abiding whether they believe a person who has an automatic firearm, artillery, a grenade, or bomb, or other like missile should be permitted bail when they're caught in possession of it. This is not about possession of a revolver, which is designed to kill someone. This is not possession of a semi-automatic firearm, which again is a scourge on the streets of Trinidad and Tobago. We are here today to determine the future and the fate of Trinidad and Tobago with a very limited arsenal of items designed for war. An automatic firearm is what you expect to see in a war zone and on a battlefield. A grenade or bomb is made for a war zone or a battlefield. So you see, Mr. Vice President, anyone who is in possession of any of these items, it is our respectful view as the persons charged with the responsibility to offer safety and security for the people of Trinidad and Tobago. We stand here without fear of contradiction and state here today in the Senate that there can be no legitimate reason whatsoever for an individual to have in his or her possession an automatic firearm, a grenade, a bomb, or any other device, or artillery. Artillery in itself, by definition, is for war. So whoever, with the greatest of respect to them, believes that a person found with an automatic firearm and a grenade in his or her possession should be permitted bail or the opportunity for bail at first instance, I beg to disagree. But you see, Senators, population of Trinidad and Tobago, we aren't even shutting the door. Because when you flip the page of the Bail Act, we have permitted, and you all not too long ago were participants in the passage of the first amendment to the Bail Act that we did for this year. And in there, what we did is we permitted for persons to go before the High Court in exceptional circumstances. Here it is. In exceptional circumstances, even in this instance that we're here to debate today, and to make a case for an application of bail. Now, it may be asked, what are exceptional circumstances and how do you define exceptional circumstances? Courts, on a daily basis, are charged with the responsibility. You talk about separation of powers. What is their legitimate role in society? They will define, the same way they've done for centuries in law, what are exceptional circumstances. And the Interpretation Act talks about speaking law, which means the evolution of law. And I strongly advocate here that those exceptional circumstances, let it be up to the person who's found in possession of an automatic gun going to kill Mr. X or Miss Y and a hand grenade to explain to a court, a high court, a judge of the high court, why he or she should be allowed back onto the street before the expiration of 120 days. So to put it in the context and the reality of what I have described.
Minister, you have 5 more minutes.
Thank you very much, Mr. Vice President. Senators, with the greatest of respect, as citizens of Trinidad and Tobago, you are blessed and privileged with the duty and the task of determining via legislation how we protect people in Trinidad and Tobago. Senator Hazel Thompson-Ahye was with me last week in the prisons and seeing what takes place in that setting with the prisons. But this is not for those that we interacted with last week, Senator Drayton. This is for those who are out there with automatic weapons and a grenade. Not even the policemen who we see on a daily basis have in their possession hand grenades. Nobody will see a policeman in Trinidad and Tobago with a hand grenade in his or her possession. And they are trained. But what we are seeing today, and the strong signal I'm asking that this Senate sends to the criminal underworld, is that if you are found in possession of artillery, an automatic firearm, a hand grenade, or a bomb-like device, you're not safe to be walking amongst us on the streets of Trinidad and Tobago. However, if you think you are, and you think there are exceptional circumstances as to why you should be allowed bail after being found in possession of any of these items of war, you have the right to go to a judge of the High Court and persuade him or her in those circumstances as to why within 120 days before your case is dealt with, you should be back out in bail. And I end by saying this, Mr. Vice President, with the greatest of respect to all of those out there. Until, God forbid, the day comes, and I hope it never happens, to anyone that any of us know or associated with, and you face down the barrel of an automatic weapon, and these weapons that we're finding being used by the criminal element out there, or worse yet, a grenade, that is when you will understand, and by then it will be too late, why the persons found in possessions of these items of war should not be permitted bail on the first occasion, and give us the opportunity to keep them inside for 120 days whilst we start their cases where they will have their day in court. But before that time, senators, make Trinidad and Tobago a safer place by not permitting these people the automatic right to bail. And that is a decision that you have to make here today. Thank you very much, Mr. Vice President.
Thank you, Mr. Vice President, for allowing me the opportunity to contribute this afternoon on the Bail Amendment number 2, Bill 2019. Now, Mr. Vice President, I, just like many other senators and persons who may have been listening to contributions, I do understand the gravity of the situation that we are currently placed in. The charged atmosphere that persons would have by simply just walking out on the street, not knowing what could in fact face you. And it really doesn't matter in some instances, because we have seen this type of gangland style activity stretching out past particular areas within this country and meeting persons within their homes, meeting persons in places that would normally and naturally be considered to be safe havens. So that we here in the opposition do understand and appreciate that something in fact has to be done. The issue I think that we have been having for some time is the manner in which the current administration has approached this situation. I do appreciate, being a lawyer myself, having been involved in the criminal justice system as well, that legislation is an essential tool to be utilized. However, we have said it time and time again that legislation alone, without the assistance of proper infrastructural changes and measures at the various institutions within this country, is not the answer. And it worries me sometimes, especially when we're dealing with a particular piece of legislation like this, that in lieu of adopting what I would consider maybe the best approach to treating with this situation, it appears then that the government, instead of aggressively pursuing a hybrid situation like that, creating legislation while assisting the correct institutions with infrastructural changes and development, is choosing, it appears, is choosing to go a step further in terms of infringing upon persons' rights within this country. And that, without proper representation to facilitate such a move, is a dangerous step that we have to be very careful about taking. Even with a sunset clause, it is something that we have to consider very carefully. And I would have listened quite carefully to both the Honorable Attorney General and the Minister of National Security in terms of what was said. I would have listened to Senator Vera and Senator Hussain as well. And I can relate. I have been the victim of a crime. I would have been about 19 or 20 when I was in fact robbed. Huh? When I was in fact robbed.
Your name is a crime.
So that I know how the effect that such a situation could have on a person. I was such a victim that I made a report to the police station, and then because the officers, the crime just occurred, they took me into the vehicle and they said, well, let's go and look for the person. And when we started to drive through the particular streets, and I started to think about how difficult this thing could be later on, I told them, you see me and this thing, let me forget that. They said, well, go home and think about it. And then the following day I came back with my parents and I told them that I did not want to go any further with this matter. So I know about being a victim. I know how that could have a psychological toll and effect upon a person. And I could appreciate trying to legislate or assist in terms of alleviating that position that an individual may be in. But whether or not this is the right tool to so do, I am not 100% convinced. And I will elaborate on that a bit later on when I get deeper into my contribution. But what I want to do from the onset of this matter is that this situation with respect to simply treating with trafficking in firearms and legislating to make it a non-bailable offense, really and truly the genesis of this particular matter has its roots, as have been mentioned by the Minister of National Security, in a decision made by a particular judicial officer. And I know Senator Vera and Senator Hussain touched on it, but what I wanted to put plainly and as lucid as possible upon the record is that the judiciary and members of the judiciary have a particular function when it comes to bail. They cannot derogate from that function as loosely as persons would want to represent to the country. And certain statements have been said within this chamber, certain statements have been made outside of this chamber, but no one has really truly explained to the public or put on the record what those ramifications or the structure or the procedure as it relates to bail involves as a judicial officer. And one particular case that outlines that procedure in itself is the case of Yassin Abubakar and the state. Most practitioners in the criminal jurisdiction, defense counsel, utilize this case. At least any of them who are with their salt would know this case inside out. And this particular matter dealt with certain statements that would have been made by the individual that were considered seditious in nature, and he would have been denied bail. And there were certain circumstances that would have changed during his incarceration during that period that moved his counsel to make an application for bail again. And the learned Justice Prakash Musai, as he then was, who sits now in the Court of Appeal, would have indicated, I think at page 5 of that judgment, what judicial officers should consider in terms of contemplating bail. And what he indicated at page 5, right, he specifically pointed out that judicial officers should consider, firstly, what could be considered the grounds for an objection to bail can be found at section 6.2 of the Bail Act. And section 6.2 of the Bail Act states where the offense or one of the offenses of which the defendant is accused or convicted in the proceedings is punishable with imprisonment, it shall be within the discretion of the court to deny bail to the defendant in the following circumstances. A, where the court is satisfied that there are substantial grounds for believing that the defendant, if released on bail, would 1, fail to surrender to custody, 2, commit an offense while on bail, or 3, interfere with witnesses or otherwise obstruct the course of justice, whether in relation to himself or any other person, and F, where he is charged with an offense alleged to have been committed while he was released on bail. Now, the difficulty with understanding section 6.2 is that police prosecutors must raise that as the ground to object to bail. They have to look within section 6.2, juxtapose it within their particular circumstance with respect to this particular defendant, and raise it as an objection for bail. That is what is supposed to happen. The prosecutor is supposed to indicate to the magistrate or the judge, Your Worship, this person, if he is released on bail, I'm objecting to this individual to be released on bail because he would fail to surrender, which can be found in section 6.2A1. Or that we believe, based upon evidence, he would commit an offense whilst out on bail. Or that we believe, based upon evidence, he would interfere with a witness whilst out on bail. Or we believe that, based upon his criminal record, once it is available at that juncture, he is currently out on bail for some pending matters, and it is alleged that he's committed this offense whilst out on bail in those matters. And then, Justice Musa indicates that in the exercise of its discretion under subsection 6.2, which I just read, the court shall consider the following. A, the nature and seriousness of the offense or default and the probable method of dealing with the defendant for it. B, the character, antecedents, associations, and social ties of the defendant. C, the defendant's record with respect to the fulfillment of his obligations under previous grants of bail in criminal proceedings. D, except in the case of the defendant whose case is adjourned for inquiries or a report, the strength of the evidence of his having committed the offense or having failed to surrender to custody. And E, which is a catch-all, any other relevant factors. So what is supposed to happen is subsequent to the police prosecutor indicating to the magistrate or the judicial officer, well, listen, I'm objecting based upon the first ground, which is 1, he would fail to surrender to custody, or 3, he will interfere with witnesses. And the factor to support that ground will now be found in section 6.3, which is the seriousness of the offense and other antecedents that the gentleman may have. And that is how a bail application, an objection to a bail application is made. So when persons simply say, who in my respectful opinion, in my considered view, are also members of the bar, senior members of the bar, go out in public or even in this chamber and say that it is a unfit decision, or it may be ridiculous in nature, that this individual may have been granted bail because of the seriousness of the offense. That is a very, to use the words of the Honorable Attorney General, infantile approach to dealing with this thing. It's an infantile thing to say. Because there's a procedure that must have been adopted for the person to make that objection and for the judicial officer in those particular circumstances to rule. I have sat in court on many occasions, and I'm certain other members, other Senate members who are lawyers as well, who practice in the criminal division, would have sat in criminal courts. And serious matters, I agree, the majority of matters that come through criminal courts, whether they are victims that are alive or victims that have passed, all those matters are serious matters. And you would have the matter come up, and the best thing, unfortunately, maybe because of lack of training, I really do believe it may have been because of lack of training, the police prosecutor, not knowing better, would indicate to the magistrate, well, we objecting to bail this morning, Your Worship, because of the seriousness of the offense. And a simple retort to that would be, well, with the greatest of respect, please, he has not indicated which ground under 6.2 he's raising this objection. And in most instances, the prosecution is left flat-footed. And again, it is not to rub scorn up or scorn upon the police or the police prosecutor. It is unfortunate that they may not have had the requisite training to properly respond. And these are the things that I am seeing in terms of infrastructural changes that should be made before we aggressively pursue infringing upon persons' rights. So that if that individual who was objecting to bail in that particular matter, where the young man or the young woman or whoever it was held with these plethora of firearms, had indicated some of these things, then maybe the magistrate may have been able to rule differently. Or maybe the magistrate would have been able to set a higher bail. But this is what the public needs to be aware of. And these are the decisions or the approaches that could have been adopted first before we even think about moving to legislation like this. I appreciate the calls that are being made. I appreciate what the Commissioner of Police has said. I do appreciate what the Honorable Attorney General said. I do appreciate what the Minister of National Security is saying. These are war zones out there. But we must, as the Minister of National Security indicated in his contribution, that persons from the National Security Council may have approached him and indicated that, listen, maybe we should consider the Jamaican model with the states of emergencies in particular parts of the country. And he indicated to them that, listen, we're not there yet. Let's try the other approaches first. Let's explore other possible options. Is it then that this was an option that was not explored by the administration in terms of properly resourcing or educating police prosecutors with respect to these matters and objecting properly to bail? This is a situation that is ongoing for quite some time. And it should be looked at carefully before we look at this particular situation. Now, the act is quite short, and I do not intend to detain honorable senators for much longer than I would want to. In looking at the act, however, I looked at Section 5, the amendments that would be moved to Section 5, and I mean, Senator Hussain made mention of it. I think the Honorable Attorney General made mention of it. Senator Vera made mention of it, that the biggest difference with respect to this amendment of including trafficking in firearms as a non-bailable offense is that when we were here in June, individuals who would have been caught by this particular part of the legislation would have been persons who, at that juncture, did not have a sanitized record. They didn't have a clean record. And I think it would have been Senator Heat, as he then was indicated the story about lightning not striking twice. And we agreed with that particular position. You have now a situation where someone who would have an impeccable character up until that particular time being caught by this legislation and being denied bail for up to 120 days. And Senator Vera mentioned the fact that there are possible scenarios where persons could be framed. And I can attest to that. One of the very first matters that I was involved with when I got called dealt with a taxi driver. Normal taxi driver applying his trade, registered HCA and whatnot. And he had this passenger who he would pick up from time to time. Didn't really know the fella too well. The fella had his number, he would give out the number, he'd pick him up. He just knew him as Redo. Right? So now and again he would assist Redo and whatnot. Redo had some kids and things. He'd pick up Redo and them sometimes Independence Square and whatever the case is. So Redo called him Adi. And Redo say, hey, listen, I have a little job for you. I have a partner, he have some fertilizer and whatnot. Let's pick him up now, he needs some transport. He said, all right, no problem. What time and where? He gave him the time. He went, he picked up the man. Man tell him, drive up the trunk. And you have these 2 crocus bags. He assumes the fertilizer, and he puts the fertilizer into the trunk. Close the trunk, passenger jump in the car, 2 of them going down the road. Lo and behold, they bounce up a roadblock. Passenger see the roadblock, and he bolt from the car. So the taxi driver sitting down in the car, I don't know what's going on with this fella. The police come now, they give chase behind the man, they come by the taxi driver, the police car capture the guy, search the vehicle, pop the trunk, open the crocus bag, marijuana, a couple kilograms well. So the police at that juncture would ask the gentleman in question, and well, where's this? And he gives them the exact same story that I've just told this Honorable House. And they say, well, okay, Redo tell you to go and pick up the man. Well, call Redo. He called Redo. And what do you think he'll get? Welcome to B-Mobile. That phone going off. And in those days, you didn't have the systems in place with respect to being able to track address with SIM card, because in those days, GSM had now come out. You just walk into your city or Digicel or whoever, ask them for a SIM card, they give it to you, and they walk out the store. So you think about it. As a police officer or a member of the prosecution being in that position, what are you to do? The law says that this man is in possession of these items, and that in terms of the deeming provision, he has to now prove. The burden shifts to him to prove to who? Not to me, the police officer, but to the magistrate or to the judge and the jury. He has to prove to them that that doesn't belong to him. So what am I to do as an officer of the court? I had to charge the man. I have to. And you think about how ridiculous that story may have sounded to the police officers. Redo tell you. You can't tell me what's Redo's real name. You can't tell me where he's live. You tell me he's picking him and his kids up. Which part he live in? Well, only time I'm picking him up at Independence Square. And this is the situation and the scenario that many persons are in. There are many of us who sit in this chamber who know persons by their nickname. But when you really think about it, where does that person live? You can attest to the fact that you know that person for over 15 years, but you know nothing about them, save and except for their nickname. And that the man might like Manchester United, and he's a fool for doing that, because look at what's going on in Man U now. That is the total sum of your knowledge of that person. And that's the position that that particular client was in. He could prove nothing beyond the fact that he was found with this marijuana in his trunk. And he was charged for trafficking. A perfect record before that point. By the ambit of this amendment, he would be denied bail for 120 days. And that is the scenario that we would be wading into. Yes, it may very well be, he may be the only person if we enact this legislation that may be caught by it. But he's still that one innocent soul that we cannot turn a blind eye to. And that is the consideration that honorable senators must attach to this particular piece of legislation. And balance that with everything that the Minister of National Security and the Honorable Attorney General would have indicated. That we are in fact living in a war zone. But what of this one poor soul? That is the level of consideration we must attach to this particular piece of legislation. And hinged to that, Mr. Vice President, hinged to that is the fact that when you read on in terms of the clause itself, you go to section 5.7. And section 5.7 indicates that if the matter is started within 120 days, no bail for you. And if it starts within the 120 days, these two amendments, the trafficking in firearms and the prohibited weapons, if it starts in 120 days, but the trial does not finish within a year, well, no bail for you. You cannot apply for bail after that 120 days if that matter is not concluded within a year. That is the legislation. So you, a person who previously had a clean, impeccable character, working your tail off to mind your family, caught in that particular situation, you have to sit down there until thy kingdom come, until your matter is concluded. That is what we are sitting here to legislate. So no matter, and not to postpone at all, no matter how gory the details are of our society, we have to consider that one taxi driver. Because that is the position he could possibly be in. I mean, we could consider an amendment to that particular section, possibly that we remove 5.7, we remove the fact that if you have an impeccable character before that particular situation and the matter isn't concluded within a year, that at that juncture you could possibly make the application for bail. But we still have to consider that you would have been inside these four walls for 120 days. And then what happens to that individual when he's in that position? You become a changed individual. Because we know the state of our prison system. There are so many knock-on effects to this particular piece of legislation that we have to consider before even thinking about just moving with it because of gory details and situations out there that are extremely dangerous. And it brings me to the point as well too. If we are to leave that situation as it is with respect to an individual having to stay inside if the matter is not completed within the year, what systems have we put in place to ensure that the DPP's office is able to treat with those matters as quickly as possible? Have we properly resourced the office so there are sufficient prosecutors to prosecute these matters? And if not the DPP's office and it is police prosecutors, have we properly resourced the police prosecutors? Because clearly, based upon the genesis of this particular matter, it appears that the police prosecution service is not as resourced as it should be. And we care about our officers, don't we? We care about the state of the TTPS. We cannot always be relying on Captain Gary Griffith to be saving the day. We have to save him too and assist him properly. This is an extremely serious issue. It also leads me to talk about the Forensic Science Center, because they'll be treating with these exhibits as they come along. I would have seen in the newspapers this talk about an MOU being signed with India and China, but no real tangible demonstration of these things actually being enacted. We would have heard that talk about this Forensic Science Center being built in Mount Hope, but no sud turning. These are the things that infrastructurally should be dealt with as well too. In my humble opinion, first, before we look to aggressively pursue legislation. And not only any type of legislation, serious legislation like this. This is no laughing matter. I agree. We live in a war zone. But is this the step that we have to take now? I also heard the Honorable Attorney General comment on issues with respect to kidnapping and I must say, in terms of kidnapping going on, apart from legislation, again, that is another perfect example of the police service being properly resourced then as well too, to reduce kidnapping. So it cannot be done in a silo. It must work in tandem with something else, and that something else is properly resourcing these institutions, providing them with the infrastructural changes required by them. And also, to just comment on this exceptional hardship and circumstance, I don't know for honorable senators to think about as well too. In England, with respect to driving under the influence and totters as they are referred to in England, there is legislation that is alive that has been developed over time to treat with persons making applications for their license to be reinstated, and it is the exceptional hardship principle. So there is some degree of development in some area of law in the United Kingdom to treat with such situations, and they do extend past the person. So if you have dependents, which is also an application that could be made in furtherance of a person to get bail, and you have a certain degree of dependence within the household that depend upon you being outside to provide for them, or you have a sick relative, these are developments in that exceptional hardship and circumstance situation that can be explored by lawyers as well too. So there's room for the law to grow and whatnot. I do agree with that. But in terms of what we have before us currently, there needs to be more. There needs to be a greater show of force, a greater demonstration that the government really and truly has the will to treat with the other issues first than just rushing into significant changes in legislation that could really affect the most vulnerable persons within our society. And until I can really see that happening, I don't know if we are at this point or we are at the point where we need to affect an individual's rights to this extent, especially a person who would have had an impeccable character before being thrust into this nefarious and terrible situation. And with those few words, Mr. Vice President, I thank you.
Senator Thompson-Ahye.
Mr. Vice President, for the record, I'd like to explain that when the Minister of National Security said that he was with me in the prison, he meant only that we were in the same space, being independently invited. So Mr. Mark will know I'm not only against him. All right. Thank you for the opportunity to speak on this very important bill. The Constitution of Trinidad and Tobago is the supreme law of our land. It has certain rights enshrined in Section 4. And as a teacher, I want to explain what enshrined means for those people who are outside. So these fundamental rights and freedoms which are enshrined and to which we are all entitled without discrimination by reason of race, origin, color, religion, or sex. Now we know what is a shrine. Some of us have been to Medjugorje, they've been to Lourdes, and we have our own Laventille shrine here. A shrine is a sacred place, a holy place. We go there to pray, not to play. And these rights, which are our fundamental rights and freedoms, are sacred. We don't play with them. We don't trifle with them. We've been assured, and we feel reassured, that the law will recognize and protect these rights which are enshrined. Our Constitution has made a solemn vow, a solemn promise to us, and we hold those rights very close to our heart. So today we are looking at an amendment of one of those fundamental rights, the right to bail. Now when we look at our Constitution, Section 5(2)(f)(3), we see that there are certain constraints, and we are told that Parliament may not deprive a person charged with a criminal offense of the right to reasonable bail without just cause. At common law, the denial of bail was considered a breach of the right of the liberty of the subject. It could not have been done arbitrarily. Now, when I used to teach law students, which was not too long ago, I would always tell them that whenever you learn a new principle of law, you have to look out for a little wicked man who is there waiting to trip you up. And that man, I gave him a special name, Mr. Exception. So during the years, every time I would teach something, I say, and what are we looking for? They say, Mr. Ahye, Mr. Exception. So we have these exceptions to the rights. When we examine what the law says, we see there are exceptional circumstances where Parliament can curtail these rights. And we know that there are some of these exceptions. We're very familiar with, for example, the state of emergency. We know about the state of emergency when we are told we can't go outside, or some people used to have emergency parties. I remember one night after law school graduation, people couldn't leave my house because the bewitching hour had arrived. I wasn't going to feed them the next day. Anyway, so we have situations where bail can be denied in certain circumstances. So when you hear without just cause, again, you see, that is a curtailment because you must have a just cause. So the legislature is given a window of opportunity to curtail that right, to limit your right to bail. So the issue is, what is a just cause? It is a cause that must be satisfied if at the end of the day you want to hear say aye or yes. So you look at what limits you have in the schedule to the Bail Act. We look at the circumstances. We look at what the Constitution says. And we see in Section 6 existing law exceptions. We've heard the Attorney General and others speak about what is reasonably justifiable in a society that has a proper respect for the rights and freedoms of the individual. And we're told that if you want to do that, then you must have a 2/3 majority. So you will hear at the end of the day a call for a division. And whenever that happens, whenever you have a 2/3 majority, you find that is when people try to be a little friendly with you because they want you on their side. So sometimes they come in early into the chamber and they smile with you. They may even hug and kiss you because that 2/3 is. Nobody heard me mention Minister Frampton Campbell. All right. So we must have the 2/3 majority, and that fact that was passed with requisite majority must be certified on the legislation. Another thing that happens is that you put into your legislation circumstances under which people are not entitled to bail. And early o'clock you have things like murder, treason, piracy, hijacking, any offense for which death is the penalty fixed by law. Now, growing up in Trinidad and Tobago, I thought once you were charged with murder, there's no way you could get bail, until I realized in other jurisdictions, they get in bail for murder. So I really thought that was the norm. But that is very special to Trinidad and Tobago. So why we have these serious offenses which are not bailable is because the more severe the penalty, the more likely it is that someone who is granted bail and facing those serious charges, those persons will be likely to abscond. So you find that you have all of these exceptions coming into the law. And during the course of the last few years, we've been coming, people, well, not we, but parliamentarians have been coming here and amending the Bail Act. 2005, 2012, 2015, 2017, 2019. We've been here for this year already, you know. And before 2019 expires, we are presented with another bail amendment bill. And many of the amendments have had to deal with accessing bail, sureties, and so on, and specified offenses. You know, whether we're adding to them, and that's in the schedule to the Bail Act. And I heard my friend a little while ago speaking about, and it has disturbed quite a few people, that you can be charged with possession and be denied bail. But when you look at the specified offenses, aren't you concerned that somebody could be denied bail for offenses such as receiving stolen goods? You may be quite innocent as well. What about buggery? So you have other offenses, and we sat here in this parliament and we legislated and denied persons bail for those offenses. But the question of possession has one that has aroused the concern for many of my colleagues. What has been happening as well is that we're adding to the list of offenses various charges coming under new legislation, anti-gang, anti-terrorism, firearm trafficking in persons, and so on. So we have a situation where we are looking at the prohibited weapons, and I know, because I read the newspapers, I listen to the radio, the genesis of it. But the fact is, we have to weigh. The genesis of it was a pronouncement in court, and it aroused the ire of the Commissioner of Police. But is that so fundamental? We know the society that we live in. We know that a number of things have been happening in society. And I have said before in this parliament chamber, I have repeated a conversation that was overheard by a reliable source, and my daughter always tells me, you know, you're telling these stories in parliament, you're going to repeat yourself. And I say some stories need to be repeated. And that story is one where some bandits were talking amongst themselves in a public place. And they were saying they fed up with the police because they were getting too greedy. Because they long ago, they would say, look, we would say we find the gun in the bushes if you give us so many thousands of dollars. Now they want more than the amount they wanted before. So we have that situation. Some years ago, I was informed, I remember at one point I was sitting at the bar table in the Beck House, so that's telling you how long it was. And there, I was hearing a story from a lawyer, a former police officer, and he was admitting to me that he had brought false charges. I was appalled, and he thought it was funny. And it didn't happen once, it happened twice. And don't come to ask me after who was the lawyer. All right? So we had a situation where former police officers are saying quite openly to me, yeah, I bring false charge already, and so on, and I didn't think anything of it. A father said to me, look, I don't like that man coming around my daughter, you know, and I have a police officer. He just said, tell me when you're ready. Tell me when you're ready, I will drop something on him. So we know for a fact it happens in the society. It happens. But in spite of that information, in spite of the experiences, I stand here today to support this legislation. I wish I didn't have to be a party to the denial of any fundamental rights. But I think it's necessary. I think it's expedient. And I think we must provide the necessary weapons for the arsenal of the police commissioner in this war against crime being waged fearlessly on our behalf. In 1993, I was attending a symposium at the Integrity Commission at the Central Bank. And there you had an acting, I think it was acting DPP, and his way of fighting crime was, you know, put all of them, all the bandits, put them in a field, let them take the guns and shoot down one another who ain't dead, badly wounded. That was the way of solving crime. There is a better way. There is a better way. The horrifying crime statistics, the brazen way in which murders are committed at any time, on anybody, in any place, leads to the inescapable inference that this is a war. This is a war that we must not lose. So with apologies to the Bard of Avon, I quote, in peace, there is nothing so becomes a man as modest stillness and humility. But when the blast of war blows in our ears, then imitate the action of the tiger. Stiffen the sinews, Gary, summon up the blood, disguise fair nature with hard-favored rage. And one day, before that sunset close, fades in the distance below the horizon, maybe one day we will say, like our own bard, remember, we passed that stage. Thank you.
Senator Chote.
Thank you, Mr. Vice President, for the opportunity to speak briefly on this proposed legislation. I feel that it is easy to speak briefly on this proposed legislation today, simply because we went over much of this ground already in May of this year, when we had been asked to agree to another amendment of the Bail Act. Now, I am glad that my colleague, Senator Thompson-Ahye, focused on what is actually confronting us. Because with all due respect to my colleagues on both sides, I think sometimes when elections are approaching, we hear a lot about other things and not so much about the legislation which we are contemplating. And it is quite accurate for my colleague, Senator Thompson-Ahye, to point out that perhaps the reason we are here is because of that matter reported in the newspaper of someone charged and being allowed bail. And I start from that because, in my respectful view, I have to disagree with my colleague, Senator Thompson-Ahye, for that very reason. And I will say that because the police in one case, or the prosecution in one case, failed to convince a magistrate, it doesn't mean that we as legislators, when we are applying the test in law which we are supposed to apply for the ouster of the court's jurisdiction, we ought not to be giving undue weight to that fact. because our allegiance and our oath is to the Constitution of the Republic of Trinidad and Tobago. Now, the other thing that concerned me, and which is something no one has really spoken about as yet, is while we had a very angry outburst about the magistrate who, poor man, can't defend himself because he's a member of the judiciary, a court officer, a judicial officer, cannot defend himself in the press as other officials can and do. The magistrate was lambasted in the media, in the press, on the platforms, and so on for his decision. One of my colleagues was suggesting that it was perhaps because the police didn't make a proper representation and so on. We have no evidence of that. Let us remember this. A magistrate, even where lawyers agree that a person may be entitled to bail, or where they may disagree, the magistrate is the one who can make a decision on the matter. And magistrates often do. You may have both sides agreeing that the person is entitled to bail, and the magistrate will say, no, this is a very serious matter, or there are too many matters like these before the courts, and the magistrate may give that factor additional weight in the exercise of his discretion under the legislation. We can't complain about that. We are not a court of appeal. We are legislators. The Bail Act provides that if the prosecution is dissatisfied with the decision of a magistrate, or if an accused person is dissatisfied with the decision of a magistrate, there is a legal forum for either the prosecution or the accused person to go before the High Court. So the prosecution, if they are in disagreement with the magistrate's adjudication, can go before the High Court and ask for bail to be revoked, or that conditions be placed on the bail. Now, quite frankly, I don't see why that is my job. That is not my job as a senator in the Parliament of Trinidad and Tobago. There is law which permits for how that situation needs to be addressed. And I see no reason why we need to circumvent that and have legislation brought in this Parliament when there are perfectly valid options open to the parties in cases like that. That is up to them. Court matters are court matters. We as legislators, we must respect the separation of powers that is deeply entrenched. That we must not be here for knee-jerk reactions because a public official is annoyed, or a public official is annoyed because his officers were treated badly. Those are opinions which should not influence us in the least. Furthermore, I have heard so many issues conflated in this honorable House this afternoon that perhaps the only explanation I can think of is because there are 2 elections in the air. Please, let us step back. Our beloved country is not at war. If we were at war, we wouldn't be having 2 democratic elections coming up. Our beloved country, according to the statistics given both by the Attorney General and the Minister of National Security, are faced with, and I'll tell you, because it was said in the debate on the 7th of May 2019, 43 submachine guns during the period 2009-2019. Weapons of war, prohibited weapons. So we heard talk of war. We heard talk about prosecutors not doing their jobs and infrastructure needed. We heard about those of us here not really knowing what's going on the ground. We heard about we must be afraid because we really don't know what happened in 1990. But many of us are old enough to know. Regrettably, I was one of those in the Hall of Justice. I spent the night on the floor of the home of the Office of Director of Public Prosecutions, together with Dana Sita-Hall, her sister, and 2 others. When I came out of that building, I couldn't get to my car because it was parked in the then Solicitor General's car park. I was a prosecutor at the time. I faced and heard those guns. So let us not pretend that knowledge or human experience about matters like these rests in the heart and minds of any particular group in here. We all bring our collective experiences and knowledge. And my concern is, why are we constantly being asked to make exceptions to what the Constitution provides for? When we came here in May, I don't know if many of you will recall, but I refreshed my memory from the record. We were asked to have bail refused or not allowed for persons charged for the first time with the possession of firearms. The Honorable Attorney General had said in his presentation then that consideration had been given by himself, the Minister of National Security, and I believe another minister as chairman of the LRC, to the issue of prohibited weapons, and that was left hanging. I looked at all of the contributions, I read them through when we went to committee stage and so on, and it was agreed that there was a great danger in having bail not be allowed for persons charged for the first time for the possession of arms and or ammunition because of the multiplicity of ways in which such a person could become charged. So we agreed in May that that wouldn't happen. But we did agree on that occasion, most of us agreed, that we will allow the Bail Act to be amended to make it more draconian in terms of how the courts could grant bail. Six months later, we are back here again, asking for yet another exception, asking for another special majority, asking for us to consider some of the very matters which we had considered in May of this very year. And I respectfully submit, as far as I am concerned, that that simply is not good enough. If we have to draw a sort of perverse analogy, it's a kind of situation where a man on a gang charge, he goes and he asks for bail from the magistrate, he doesn't get it, and every time the case comes up after that, he is there asking for bail, perhaps doing very well, what the response is likely to be if the magistrate had said this is a very serious offense and the case against you is strong and so on and so forth. I think that unless we have some sort of solid basis in terms of data, in terms of, build-up of weaponry in a particular area and this kind of thing, then perhaps I may have considered it differently. But even if we had that, I was thinking, isn't that a matter for policing? For the police to seize and charge, and hopefully the person who is held in possession can be kept in custody, and we can find out who placed those guns there, who he bought it from, who brought it into the country, and things of that nature. As my colleague Senator Richards had said during the lunch break, we look too much to the end product without looking to find the source. And to me, if we are doing that kind of cosmetic thing to policing, then don't come here and ask for a piece of legislation to be passed which infringes upon a constitutional right. Go to the court, use the avenue open to you in the courthouse, and ask for the bail to be revoked. But don't come here and ask us to make exceptions to the Constitution. I have a fundamental problem with that. The irony of this, Madam President, and it is an example used in May of 2019. The irony of this is the very same commissioner who had expressed dissatisfaction with this magistrate's ruling, when asked about the shooting of the young girl Naomi Nelson by the Newsday on the 9th of June 2019, had said he didn't know how long that case or that inquiry would take. Because, ballistics could take up to 6 years. So, is it that there's one practical experience when police officers are being considered as possible suspects in the shooting of a young girl, and one for other persons? I didn't know that our Constitution applies differently to different categories of people. I thought it applied to all of us in the same way. So this whole thing about, okay, we'll keep you inside for 120 days, right? So you could get your trial done. That's a laugh. That's a laugh. That's an insult to my intelligence. In the 3rd decade of practicing law in the Republic of Trinidad and Tobago, who gets a trial done in 120 days? So the only purpose then of the incarceration for 120 days is punishment. And we also talk about philosophy and conflated philosophical reasons for this and that and the other. Well, let's talk about punishment. And let's go to the root of this. What you want to do is you want to punish the person presumed to be innocent by incarceration for 120 days, knowing full well no case is going to start and finish in 120 days, without any regard to the statistics in relation to this particular kind of crime, because we, apart from the number of 43 submachine guns, we've been loaded up with statistics about different kinds of crimes and firearms 365 of the murders committed with firearms. So I started to ask myself, after 3 decades, you become a little cynical. 365 murders with firearms. So we have a bail amendment act here talking about prohibited weapons and certain kinds of artillery. And we're being asked to treat with that in a certain way to say no bail for 120 days. So is it that we're going to come back here in the next few months and say, well, remember you amended the Bail Act and there's already a category of weaponry for which you can't get bail. So we are asking you now in this war that we are fighting, where there have been 365 murders alleged to have been committed with firearms, we are now asking you to say that there shall be no bail for this kind of offense. Call me suspicious, perhaps call me paranoid, but I cannot rule it out as a possibility. Certainly when we were asked to amend the act in May of 2019, I didn't think that we'd be back here. If you read the transcripts, as I have done, I didn't think we would be back here in November of this year with this proposed amendment. So, Honorable Madam President, I oppose this proposed amendment. I could be standing alone. At the end of the day, so be it. But I think the proposed amendment is unconstitutional. It is not warranted in law. It is not warranted in fact. And I believe that from the contributions I have heard, that we need to refocus on what test we should be applying when we treat with applications for the amendment of legislation requiring a constitutional majority. We need to focus our minds when we address this piece of legislation to those considerations. In spite of the heat and the furor and whatnot, I would respectfully urge us all to step back a bit, think with a clear mind, and apply the test which we should be applying as legislators. Thank you very much, Madam President.
Minister of Agriculture, Land and Fisheries.
Madam President, thank you very much for the opportunity to join in this debate on this bill to amend the Bail Act for a second time. Madam President, when the Honorable Attorney General made his contribution, I took note of a phrase that he used, and I think it's worth repeating. He says, this bill is deceivingly simple. I hope I got it right. Deceivingly simple. I focused on the simple more than the deceiving. But I feel that some of my colleagues have been deceived. This is not a debate on the denial of bail, which was addressed in May 2019. And this is not a debate on firearms legislation. I think the simplicity, Madam President, comes from the chronology of things. When the bail amendment bill was dealt with, the one that was assented to in August 2019, the firearms bill had not yet been debated in this place. And one of the most important things I remember contributing on the firearms bill, and several of us would have made the point, that that bill, Act number 18 of 2019, was introducing a brand new but very important offense. and that is this offense of trafficking in firearms. I remembered making the point that when I considered at the Legislative Review Committee the firearms bill as it was presented, considering the definition of firearm, I saw the opportunity in my community, in particular in relation to hunting and hunters. I saw the opportunity for people who were committing an offense, but an offense that may not have been contemplated in this trafficking offense we were creating. And I then made the point that I resolved myself around the fact that we had to address a significant national issue. And I felt that my concerns ought to be minimized. But it is the creation of that offense through the inclusion of a new provision in the firearms legislation, 9A, that brings us back to this House today. It is the creation of that new offense after the assent to the bail amendment that brings us back to this House. In other words, if the firearms amendment was passed before the bail amendment, the bail amendment would have addressed the offense of trafficking. It would have addressed it. But it couldn't. And that is the simple reason we are back here today. And we all agreed, I'm sure, that that issue of trafficking had to be brought into law. We had to distinguish between those cases where there was possession of a firearm or a part of a firearm, and where there was possession of more than one. And if, I remember making the point, if you want to stretch your logic and find a defense for somebody being in possession illegally of one firearm, I don't think that you could really justify being in possession of more than one. And we discussed in this House the proliferation, the way it is brought in, the way it is handled, the many handlers and many persons whose eyes have to be turned away for guns to get into this country. So this trafficking in firearms was to me the centerpiece of that bill. And in that sense, the AG used the expression simple, that chronologically, we had to come here now to deal with that offense. And Madam President, we are trying to do three things in this bill, none of which ought to reopen a debate on denial of bail, proliferation of firearms, or anything like that. We've gone past that. And if there is to be a challenge, separation of powers allows for a place for that to be challenged. Madam President, last week, in the Special Select Committee appointed by this House to consider the amendment to the Evidence Bill, Evidence Act, the Director of, it was a public hearing, Madam President. The Director of Public Prosecution was before us, and we all appreciated his presence. He was very frank, and took up a significant part of the opening hour. And he used an expression, cocktail. He was making the point, Madam President, that in the circumstances of this country, we need several things to be put together in order to deal with crime. And the Director of Public Prosecutions was making the point in support of the evidence amendment that we needed what was in that bill, alongside other things. I know my friends attempted, and Senator Sobers opened with that temptation of going back into the failure of the institutional arrangements, the resources which have to be put towards enforcement and all those things. I've said on many occasions, our job here is to make the law. Somebody else's job is to enforce the law. Our job here is to make the law. And the Director of Public Prosecutions was speaking in support of a law that he felt we needed, and we needed to put in that cocktail. He says, a cocktail of solutions is required, and some of them are not easy to accept. And the incarceration of anybody is something that is not easy to accept. Family members are found wailing outside both the prison and the courthouse. Family members are found running down the Black Maria. They on the outside screaming and those on the outside pounding. But that is what we need, Madam President. That is what we need to deal with the circumstances that we have. Because I don't know where some of you live. I don't know where you walk. But there are a lot of young men in this country. It's not the community leaders again, you know. Even the community leaders, when you talk to them, tell you that they're backpedaling at the hands of these young men toting weapons of war. Not firearms, you know, I'll get to that. I'll get to this inclusion of prohibited weapons shortly. I'm just on 9A. Even seasoned criminals and gang leaders in communities are telling you that these schoolboys with AR down their pants have them trembling. And if they have seasoned criminals, if Mano Benjamin was around still, Mano would have had to cool himself. And Mr. Khan will tell you that when we were growing up in our community, you had to clear the street when Willie Smith come out for a stroll. Until a youth man, 1980s. 1980s in Rio Claro. Until a youth man put a knife in Willie Smith. So, Madam President, what the Director of Public Prosecution was talking about is a serious situation in this country. And it plays out every day before us, every day. And the Commissioner of Police, Director of Public Prosecutions, and those involved in law enforcement have asked for this support. And the fact is, when these criminals are taken off the street, law enforcement officers find it easier to do their jobs. So in relation, Madam President, to the First Amendment, which is at Clause 3, proposes the insertion under subsection 3 of a new paragraph in the first instance, AB. And going back, Madam President, it is that what is now Act number 17 of 2019, that bill amendment from March 2019, sought to insert a new subsection 3. And this bill seeks to insert, after that subsection 3A, a new provision, AB. And it refers to 9A of the Firearms Act, which is a trafficking offense that was created. And it says that if you are charged, whether or not you have a pending matter, whether or not you have a conviction, if you are charged with being in possession of more than one firearm, if you are charged for a trafficking offense, then there is no bail in the first 120 days. Madam President, I could tell you, when we sat at the LRC to consider this particular provision dealing with the offense of trafficking, we also considered that we seem to be treating firearms as a generic thing, as treating all of them alike. And we were not paying sufficient or any attention to prohibited weapons. And Madam President, the Firearms Act contains a definition of firearm. But it is in the definition of prohibited weapon that you get to the meaning of prohibited weapon. Any artillery or automatic firearm, any grenade, bomb, or other like missile. And thank God so far, we don't have an issue to confront with grenade and bomb and missile. But there was a time very recently when we did not have to contend with ARs. And it seems from what we're seeing happening with the police and what we're seeing happening in the media, the AR is becoming pervasive. But that automatic firearm is also defined. And I want to refer to the definition of automatic firearm. And Madam President, automatic firearm means any firearm so designed or adapted that if pressure is applied to the trigger, missiles continue to be discharged until pressure is removed from the trigger or until the magazine containing the missiles is empty. And these young men with the ARs down their pants, they have come out for war. And they've armed themselves with a weapon that could level a classroom, could clean up a schoolyard, deployed in a market or something. It would level not one, not two, but dozens. And around the world we see it playing off. We just haven't had our share of it here. As far as I know from my own experience, if you want to see ARs, go to some of the funerals of the criminals. They end the evening with an AR display. And so far we've been fortunate, Madam President, that one of these youngsters has not pointed that at a classroom full of children in the school to settle a score. And none of them have not walked into a movie theater to settle a score, because down in Carnage, a Sunday evening, they've gone down there and killed people on the beach. They've done it in Maracas. And it's only matter of time, Madam President, before we come to this. So when we were considering this amendment, we paid careful attention to this treatment we've been given to firearms, and this treatment we've not been given to automatic firearms, which gave rise to the second amendment being proposed. And I would readily say, Madam President, that when we did the bail amendment bill in May 2019, I would admit that the opportunity existed then for us to include this amendment. It existed then because the offense existed then. And for whatever reason, it not being brought forward, it is here now. And I cannot contemplate any one of us in this house sitting with the prospect of ARs that we know are here, that we've seen that we've seen photos of 6 and 7, that we do not believe that we have a responsibility to enact legislation to deal with the holders of weapons like that who have no right or reason to hold these weapons. Because the courthouses are there. You have more courthouses than houses of parliament. So they have an advantage. They have an advantage. And they have access to lawyers in this country. You don't need the sanction of the state to hire a lawyer, you know. A Trinidadian who operates in Canada, Selwyn Romilly, in a judgment, he described the legal aid system as platinum support for criminals. A support that in any other aspect of life you would not get that support. If you are a parent needing help to read a scholarship agreement for your child and understand the legislative jargon, you could not walk into the office of the state and get free legal advice for that. But if you are a criminal in this country, you could get legal support on my back and yours. And if your parent or my mother, as recently happened, had a pain, and my mother had a pain, and it took 3 months for her to get an MRI done. But if she was a criminal, grazed by a bullet, she would have been carried into accident emergency and stitched up. Where the criminals injured in a shooter, where they go? Where they go? In the hospital under police guard. While you're on a list, police carry them, while my parents and yours have to wait for a call from you or Mount Hope. It's time to even the odds, madam. It's time to even the scales. Nobody has a right to be protected by unwilling legislators if they walk in the street with ARs that could level a classroom full of children in this country. And that is my responsibility, Madam President. Today we distinguish between the trap gun, the pistol, and the automatic firearms that we going to deny bail if you're found with it.
Minister.
And the third part of it, Madam President, of what we're seeking to do.
Minister, just one question. At the beginning of your presentation, you said you could not bring this amendment because the firearms was not yet enacted. And yet you are saying that in May, so please forgive me for not understanding, you said in May that you did have an amendment that could have been brought, but for some reason it wasn't brought. Could you please explain?
So to clarify, when I opened, I was dealing with the first amendment, which is in the bill, the proposed clause 3, A, AB, which deals with the offense of trafficking. And the firearm amendment bill, which was debated after the bail bill, created that offense. Okay. My point is that we could not deal with it because the offense was not created. Okay. Having moved to AC, I have admitted that possession of a prohibited weapon existed in law as an offense. And we did not deal with it, even though we could have. But we've come to deal with it. And then the third area for amendment, Madam President, is the insertion after subsection 3 of section 3A. And that, Madam President, is not as simple as the AG says, but important. It's important. And while the Firearms Act has a definition of prohibited weapon, which contains 3 elements: artillery or automatic firearm, B, grenade, bomb, or other like missile, and C, any weapon of whatever description or design which is adapted for the discharge of any noxious liquid, gas, or other thing. That C in the definition of prohibited weapon is not repeated in this subsection. In other words, the definition of prohibited weapon for the purpose of 3A, AC in this bill is only the first 2 elements of the definition of prohibited weapon. In other words, we've left out the noxious liquid, gas, or other thing. In other words, if you are found with pepper spray, which is either a noxious liquid, gas, or other thing, if you are found with something like that, it does not fall within this restriction. We've accepted that we should not go that far. Now, what if the possession of pepper spray is introduced into law? The opportunity to possess it within certain conditions, and we find that a problem is created, and in true Trinidad and Tobago style, we cannot accept responsibility. So we possess it without meeting the requirements. Then a day, some other time, a group of us will sit in a house like this and deal with that. But we do not believe that we ought to be dealing with the definition of prohibited weapon for the purpose of this section at this time. And we've restricted it to artillery, automatic firearm, grenade bomb, or other like missile. And in that way, Madam President, the AG used the expression deceivingly simple, that if you go looking in this to reopen a debate on bail and denial of bail and firearms and all of that, you're really looking in the wrong place. This seeks to deal with an issue that arose on account of the chronology of things. We've corrected that. It deals with something we should have dealt with before and we did not. And it narrows the definition of prohibited weapon for the purpose of this section. Madam President, this is necessary. And you troll social media and you look at the newspaper and you understand the necessity of it. It is not an overreach of the power of the executive, and if it is beyond the powers of this legislature, then there is a place for that matter to be addressed. And it is not political. It is not political. To say it is political, it places the DPP in a position that you would argue with him. But I am satisfied that the Director of Public Prosecution appeared in public last week, public hearing of the Parliament, to deal with another bill, but spoke about a cocktail of solutions that is required, some of which are not easy. This, to me, is an easy, sensible, logical fix to a problem that has become more and more pervasive. And if it takes one AR holder off the street, we would have done our job. I thank you.
Madam President, I beg to move that the Senate do now adjourn to Tuesday, the 19th of November at 1:30 p.m. During that sitting, we plan to conclude debate on this bill. Yeah.
Honorable Senators, the question is that this Senate do now adjourn to Tuesday, the 19th of November at 2019 at 1:30 p.m. Those in favor say aye. Those against say no. I think the ayes have it. The Senate now stands adjourned to Tuesday, the 19th of November, 2019 at 1:30 p.m.